Good morning, Your Honors. May it please the Court. Alexi Tomasco for the Commonwealth. With me is Assistant District Attorney David Amanu. There are two motions to dismiss that the Commonwealth is appealing from. The first is a dismissal based on a McCarthy motion on grand jury testimony. Of course, I'm sorry, Your Honor, did you? The standard there is whether or not there is any evidence that a defendant committed an offense. And I think
could I just ask you a question about that?
Mm-hmm.
The McCarthy motion, as you put it. That was, do you disagree that was without prejudice?
I believe that was without prejudice, Your Honor.
And is there something special about juvenile practice that would mean that the district attorney couldn't seek to re-indict?
We could have re-indicted, Your Honor.
And you didn't because?
Your Honor, it is within our discretion under Rule 15 whether or not we choose to appeal a motion to dismiss. There's nothing within Rule 13 or within Section 33E that requires us to simply re-indict. Given the particular history of this case, it certainly is one thing that may be considered, but I think, again, under Article 30, it's not something that we necessarily need to get into or explain.
Okay, but doesn't that, given that, as you say, it was without prejudice and you could have re-indicted, doesn't that kind of undermine your saying that this was a dismissal upon a dismissal? In other words, that you couldn't dismiss an already dismissed case? One was without prejudice, one was with prejudice?
I'm not sure there's any no, Your Honor. I mean, the simple answer is no. Once the case is dismissed, it's dismissed. There's no continuing proceeding within the court. Similarly, I mean, if the case had been null-prossed, something that we could have brought back, I don't think there's any way that a court can then come in and sort of say, yes, we know that you've stopped this case, but we'd still like you to continue and perform. The dismissal entered, and a dismissal is a dismissal, even if we can then come back. The case ends upon dismissal.
But if the question is there was a preceding discovery order, it's dismissed without prejudice. It wasn't. I don't see anything in the record to say that the district attorney had said we are not re-indicting. Why is that so wrong or inappropriate for the judge to say, no, you need to give that discovery because for the reason she gave, that is, I haven't decided whether I'm going to grant the motion to reconsider, or because you may well re-indict, and this is a defense that this juvenile has not been able to develop because you haven't produced the material that's been ordered.
The legislature could change 33E, I believe it's 33E, to prohibit the Commonwealth from being able to appeal an order dismissing without prejudice. This court could change Rule 15 to prohibit that.
No, I'm not arguing that you can't do that, but I guess I am saying you dismiss as totally without, that the judge was without authority to dismiss with prejudice once, for the reason that she did, given that she had earlier dismissed without prejudice. And that's where I'm really focusing on.
Your Honor, simply put, I don't see a distinction there. I don't see a distinction between any kind of temporary suspension via a null process or anything else. I don't see, but we have that power. I don't see, once there's a final disposition.
Then you don't have any obligation to give any discovery. Right?
No, once a case is dismissed. Similarly, if it was in the process of appeal, and I think that's actually a particular relevant issue here, where trial proceedings are supposed to be stayed, this defendant filed an additional motion to dismiss while this case was before this court. The juvenile court considered that. That was a dismissal. I mean, that was a Commonwealth appeal. Under Rule 15, that should have been stayed. I'm not sure if this court would be satisfied if the same thing had happened, that the Commonwealth, the case would have been dismissed with prejudice. We would have done an appeal. The court would have basically decided, even though the process should be stayed and it was dismissed with prejudice, we're going to continue to request that the Commonwealth order or produce discovery. I don't think that there's necessarily a distinction there. And certainly that happened in this case where the matter should have been stayed, and this particular motion to dismiss continued. So I don't, to the extent that there's some kind of lingering case, I think that would exist similarly if it had been dismissed and we had proceeded to appeal. I think under a dismissal with prejudice, had we brought our Rule 15 motion and continued at that point in time. I don't know that there's necessarily a distinction.
Going back to the grand jury.
Yes, Your Honor.
Was the grand jury asked to find infliction or threat of serious bodily harm?
Your Honor, it's a perfectly good question. In terms of the elements that are put forward to the jury, those tend to not be put forward during the recorded testimony. So generally, the prosecutor will describe what the elements of the crime are. So,
do we know whether or not the jury made a finding necessary for a youthful offender indictment? Because I guess it was not included in the indictment, so we can't rely upon the indictment for that. Correct?
I believe so, Your Honor.
Okay. Do we know that the grand jury made that finding of probable cause to believe that there was infliction or threat of serious bodily harm?
It's certainly not in the record, Your Honor, and to the extent that that's not in the record, it's something that should have been developed by the defense attorney and by the court. To the extent...
And you can't...
How can it be developed if they're not in the room? You're the only people that are in the room.
An evidentiary hearing where, for instance, the judge requests an affidavit from counsel.
And you can't tell me today whether the grand jury even made that finding.
I'm happy to ask counsel, but it's certainly not in the record, and certainly the Commonwealth's position has been that it's the defendant's burden in this situation.
Is there a problem that there is a necessary element of an indictment and we have no assurance from the indictment itself that the grand jury even made that finding?
What this court said during Quincy Q is that that evidence has to be before the jury, the grand jury. It is certainly true that that evidence was before the grand jury in terms of both the case of the defendant.
Are you suggesting that the grand jury can bring a youthful offender indictment without making that finding of probable cause?
For purposes of McCarthy, Your Honor, that evidence is before the grand jury. If we're getting into the larger Apprendi issue...
Try my question.
Yes, Your Honor.
Are you saying that a youthful offender indictment can be brought without a finding by the grand jury of infliction or threat of serious bodily harm, where that is the only element that would be appropriate for it to become a youthful offender indictment?
I believe Quincy Q says that has to be a finding by the grand jury.
Okay, and we don't even know, and you can't even tell me whether or not it is.
I believe under
not that was made.
Under McCarthy analysis, Your Honor, I believe there was evidence of serious threat or infliction of serious bodily injury.
But McCarthy essentially tests whether or not there was adequate basis for the grand jury to find probable cause. Here, we don't even know whether or not the grand jury made such a finding. How can the indictment proceed without assurances that the grand jury made that finding?
Let me tease out, I think there's two portions of this question that I would like to address. The first is whether or not there's any requirement of a verdict slip where a grand jury has to check off each element. And the case that situation is no. I think the second question is, does an indictment by its face have to list multiple elements, such as a youthful offender indictment listing these two? I have two responses to that, and the first is the Apprendi argument, which I can address, but I believe under these circumstances, under Clint C., where this was not heavily dealt with both in motions or by the court, that's not properly here. The second answer is under Allison, where under the Article 12, there's no requirement that the Commonwealth has to list every single element, and Allison is quite clear on that point. I think I make this distinction.
I missed that. Say that again.
Under Allison,
Go ahead.
there's no requirement, this court's case in Allison, there's no requirement that an indictment list every single element of a crime, and that's seen frequently in common law crimes, for instance. Under the Fifth Amendment in distinction, in terms of federal cases, there is that requirement, and that comes in United States versus Jones. In Hurtado versus California, the United States Supreme Court made quite clear that the Fifth Amendment, to that degree, to the definition of indictment and the indictment process for the states, the Fifth Amendment is not incorporated as to the states in that situation. So when we're dealing with Apprendi, we're dealing with Sixth Amendment issues, not Fifth Amendment issues. Apprendi therefore defines and says, quite as Quincy Q found, that a grand jury or a jury has to find those elements, but not that it necessarily has to be listed into the indictment. So is there a verdict slip before grand jury? No, absolutely not, but there's no requirement that it be. Is there a requirement that every single element be listed in an indictment? No, Allison quite clearly says that's not the case. And therefore, what we're left with is our McCarthy analysis, and we look as to whether or not that evidence is there. We look in a light most favorable to the Commonwealth. We look whether there's any evidence. The court properly found that the age was there.
If we can turn from McCarthy to Odell.
Okay.
I gather that evidence was presented of what the mother said to the police officer.
Yes, Your Honor.
But not as to what the alleged victim said during the same interview, and apparently that is contradictory to what the mother said that the son had said to her. Why does that not raise a question of whether or not the grand jury integrity was impaired by an unfair and misleading presentation?
What the parents told the detective that the victim said to them was, quote, the juvenile would push his pants down and then push him to the floor. He would then, quote, put his penis in my asshole. The defendant does not contest this. This was in the police report, and Detective Wade recited that to the grand jury.
But
what the defendant contests is the following statement from the grand jury. The victim stated that the juvenile would be standing behind him, and the juvenile would pull his pants and underwear down, and then he would force the victim onto the ground and enter him from that position. What does the defendant not contest? It's very clear that the transcript says that the victim would pull down the pants and the other pants. There's no question.
it's about the forcing to the ground. And
There's to the forcing to the ground, Your Honor.
Yes.
And I would make 2 points. First of all, once that statement from the family comes in, it's a cumulative issue at this point in time.
It
and there's
isn't
not
cumulative, though, is
The-
it?
the-
Because you've got you've got the victim, alleged victim, who is not saying. I mean, where force is the key issue here.
I disagree with that point, Your Honor.
Well,
Force
it relates
is not
to harm. And I would suggest that is a key issue. Whether there's an infliction or threat of serious bodily harm is a key issue here.
Your Honor, I would point strongly to Clint C. and state that the court very clearly said there was no threat of harm there. There was no threat at all. And I would point out further that I think the defendant suggests that force, and the court suggests that force is a part of Section 54. It's not. I mean, it's simply not in there. As opposed to the particular crime that we're dealing with, force is not an element of statutory rape, and I think that's an error of law. I think that's simply the case. That said, I can examine this saying, and it's worth saying that. We're talking about Appendix 43 through 44 of the Sane interview. The victim clearly says that the juvenile, quote, made the victim just like stay where he was when the juvenile put his penis in the victim's anus. The juvenile does not challenge that the victim said he would, quote, move so like he wouldn't like get it in. On the same page, the victim witness advocate asks the victim, was there any other circumstance? Was there any other entry? And the victim said, and it would also happen on the floor.
We have read this.
Well, Your Honor, I mean, I think to the extent, I simply do not see any evidence that this arises to an egregious or misleading issue. And it's very clear, for instance, that Mayfeld said, inaccurate statements made in good faith do not require dismissal of an indictment. And the court specifically said there was no finding of any misconduct. Again, at issue here is that there's more than one requirement under Odell. There's no finding that there was any
Is that because you're saying that being forced to the ground is not necessary here? That the mere penetration is sufficient?
Clint C. said a single act of oral penetration creates the threat of serious bodily injury.
Okay, so you're saying that any act of vaginal or anal sex by somebody under the age of 16 is enough to bring a youthful offender indictment, even if it would otherwise have been consensual but for their age?
I think 15 acts of oral rape and an additional several acts of anal rape and additional several acts of oral rape under these circumstances is definitely sufficient, particularly
For
where...
these circumstances, that's not my question. My question is apart from age, if it was otherwise consensual vaginal or anal sex, is the penetration sufficient to bring a youthful offender indictment, because that by itself is sufficient to find the infliction or threat of serious bodily harm?
Clincy and Quincy Q strongly suggest
Okay,
that
but those
point.
are very, very young children. Those are children who were ages 3 through 6, not 14, or not 13, 14, or 15. Are you saying it doesn't matter?
Your Honor, I don't believe that this court or the legislature has said that there's consent is not relevant to 5-year-old statutory rape, but it's
No, it's not the issue of
quasi-relevant.
consent. Put aside, I know it's statutory rape. The issue is whether there's infliction or threat of serious bodily harm necessary for a youthful offender indictment.
Or threat.
Right, infliction or threat. So my question is, apart from age, assume they're 15-year-olds, assume it's otherwise consensual but not consensual as a matter of law, it's statutory rape. Are you saying that penetration alone, whether it be 1 time or 10 times, is sufficient by itself to support a finding of the infliction or threat of serious bodily harm?
I believe Clincy and Quincy Q say that. I strongly disagree with Your Honor's characterization that there's somehow quasi-consent. There's no consent.
I'm not speaking of this particular case, but, okay. All right.
All right, we'll have to leave it there, counsel. Your time is up.
Thank you, Your Honor.
Thank you.
Thank you.
Well, counsel, before you say what you have to say, could you help me distinguish the Clincy and the Quincy cases? Your brother seems to look at them as giving us the final word on this.
I believe that Clincy and Quincy Q do provide the guidance with respect to what constitutes serious bodily harm. In Clincy, the juvenile was 15 years old. The complainant
was 3.
The complainant was 6 years old. In Quincy Q, the complainant was 15 to 16, and the complainant was 3 to 5 years old over the course of the conduct. In both of those situations, there was a relationship of authority. In one case, working in a daycare center. In another case, babysitting. The children were particularly vulnerable because of their age, and that's what developed the Clincy factors that courts have referred to oftentimes, because in Clincy, the court said, penetration may not be sufficient in and of itself for an indictment, but in these circumstances, in Clincy, these circumstances, and the court went on to list the circumstances, the age difference between the children, the position of authority of the juvenile, and the vulnerability of the very young child. Those are the Clincy factors that are referenced in other cases.
Quincy Q, the indictment at issue was for, the only one discussed by the court was the indecent A and B, because the rape he had been acquitted of that.
That's correct, Your Honor. And in that case, the court found that although the Clincy factors were present in Quincy Q, the touching was not of a harmful or serious nature. There was not penetration. So those are the cases that provide the guidance that there is penetration plus the Clincy factors. And that's what the court looked at in Clincy. That distinguishes our case dramatically, as the juvenile court judge found here, where the children were 13 to 15, or 13 to 16 at the time of these events, that they were both Asperger's children, with our client having it documented in the record that he functions at a emotional and sociological age of 2/3 his chronological age because of his Asperger's, and they were friends with a relationship that was encouraged by the complainant's mother. Our client had no position of authority, had no had no less vulnerability, perhaps greater, because of his disabilities, and they were close in age. To just get back to the first issue, which is the dismissal of the case with prejudice on the failure to produce discovery, The juvenile court judge was absolutely correct that the Commonwealth's conduct here was egregious, deliberate, and repetitive. I'm not going to repeat all of the history of this case, but I will note...
I take it the case had been dismissed before the rescript even issued from this court on the question of discovery. So in other words, they should already dismiss the case.
No, Your Honor, the case had not been dismissed. What happened in this case is that this court ruled on Washington W. on, I think, June 25th of 2010.
The rescript issued a month later.
And we were back in juvenile court on July 8th of 2010. At that point, the judge said, I have reached a decision on the motion to dismiss the grand jury issues. I've written a decision. And there are still 2 delinquency complaints pending for indecent A and B. What do you want to do with those?
Okay, so the dismissal, in other words, the dismissal with prejudice was on the indecent A and B, because that was the only thing that was surviving.
And that was not with prejudice. That was a grand jury issue that she dismissed without prejudice.
Okay, now I'm really confused. She didn't dismiss the indictments without prejudice?
On the grand jury issue, no. On the discovery issue, yes.
I'm sorry. When did she dismiss the indictments for rape?
The indictments for rape were initially dismissed on July 2nd when she came back. When we went back to court, I think her decision was written that first week. She handed it out to the parties on July 8th. She said, this is the ruling on the YO indictments. You still have 2 delinquency complaints pending in this court for which discovery is due.
Okay.
What do you want to do with those?
Okay.
And the assistant district attorney said, well, I'm going to have to talk with my office and I'll figure it out. And she said, fine, let's have the discovery. Let's keep this case going. The prosecution said they weren't ready to produce the discovery, even though it had been several weeks since this case came down from this court. And the judge said, we argued in order to get the discovery produced at the next court date. The prosecutor promised he would produce it on August 12th, the next court date.
I understand it, but get to the end. Did she then dismiss the indictments again?
She had the indictments dismissed without prejudice, but the Commonwealth, before the August 12th, the next date, filed a motion to reconsider the dismissal on the grand jury issue. So now we have, when we go to court on August 12th, 2 pending complaints for indecent A and B, and a motion to reconsider the dismissal of the YO. She said, I want this discovery. Prosecution argues, I don't have to produce it. The judge says, I disagree. There's 2 delinquency complaints pending and a motion to reconsider, and instructs them to have the discovery ready at the next compliance date. That's it. It has to be ready. She sets a date of August 31st. August 31st comes and goes. No discovery is produced. There's no reason given. It just, nothing happens. We come into court on the next date in September, another status date. The juvenile judge who had been on the case the previous times was not there. A new juvenile court judge was there that day. She said, we represented that the judge said this was it. The discovery had to be produced. She said, well, I'm going to let Judge McCallum deal with it because these were all her issues. We'll put it over for another date. On that date in September, the prosecution tried to argue to that juvenile judge the same thing that the earlier judge had said, no. This says a motion for reconsideration pending. I want the discovery to get going. She said they have been waiting for this discovery since March of 2009.
Okay,
Let's get the discovery. So we go to court on October 7th, which is the next date when Judge McCallum was in court. On October 7th, she says to the parties, I have written my decision.
Denying your motion for reconsideration.
Denying your motion for reconsideration. I have it here. It hasn't been docketed yet. She hands it out to the parties. It's the first we've seen it. She says, what about this discovery?
So now the case is, now the indictments are dismissed, and she's denied the motion for reconsideration, and she still says, well, what about the discovery?
Because, Your Honor, there is a motion pending to dismiss with prejudice because of the Commonwealth's failure to produce discovery in all of that time. These were pending at the same time, the motion to dismiss without prejudice, the motion to dismiss with prejudice. If they'd been joined as one motion, it wouldn't have perhaps presented this issue because she could have ruled on both. There were two motions pending, one with prejudice, one without.
When was that one filed? The motion to dismiss
With prejudice, beginning of October, October
1,
1st,
I
I
think.
believe.
Yeah, that's right.
But had the indictment, the rape indictment had been dismissed on July 2nd without prejudice?
That's correct.
Was that same indictment, it was the order for dismissal was reconsidered, and the reconsideration was denied. The judge then amended the order of dismissal for dismissal with prejudice?
No, these were two completely separate issues, Your Honor. And she had not entered the dismissal without prejudice on the grand jury issues on the docket on October 7th. On October 7th, both were open issues. The motion for reconsideration, she certainly had a decision ready, and the motion to dismiss because of failure to produce discovery, which was going to be heard that day. And in the context of those two issues being talked about, she said to the Commonwealth, do you have the discovery here today? Maybe we can resolve this.
How can it be resolved? She's just, what is to be resolved? She's just told him, I've denied your motion for reconsideration, so the indictments are dismissed. But maybe we can resolve this?
Well, I shouldn't have said resolve. That was not her word, Your Honor. She was looking for a way to figure out what to do with this case that had been pending for such a long time. Is there a way to talk about it? Is there a way to resolve it? Because it was clear they were going to be appealing everything, and then this whole thing would start all over again. And she's looking to do what juvenile court judges try to do, which is to resolve a case as a parent would try to, without having it drag on for 5 years, without exposing a juvenile to adult penalties, to try to resolve it. And she's being as cautious as a judge can be by saying, I haven't entered these yet. What can we do about it? And the prosecution says, we're not producing any discovery, and holds it up and waves it at the judge and says, we have it here, but we're not turning it over. And the judge even goes so far as to say, why don't you let me look at it, let's have it under a protective order to see if the discovery is here. And the prosecution says, no. And at that point, the judge said, all right, let's hear the argument on dismissal with prejudice. She hears the argument on dismissal with prejudice. She enters both dismissal orders on the docket on October 7th. And that's what happened on the case. They both went in on October 7th.
Was there no, I'm sorry, you finished.
No, and as of that point, the complaints had been null prost, so they were no longer pending.
The assault and battery complaints were
been
null
null
prost in
prost.
September of
So
2010.
this is, the only thing is the indictments at this point.
That's right.
Was there ever any discussion about the possibility, since the first motion to dismiss was without prejudice, of re-indicting?
We had said there would be a possibility to re-indict, Your Honor. The prosecution made it clear they were not going to do that. The judge was quite, the judge made it without prejudice to afford them the opportunity to re-indict, and they chose not to. And I think that says a lot about what they believe the quality of their evidence is. The fact that they would not re-indict, the fact that they would not use a YO indictment like most counties do, that have on the face of the indictment the YO factors that a grand jury must find. If you look at indictments in Suffolk County and other counties, they have it in the indictment to ensure that those factors are determined by a grand jury. Post-Apprendi, post-Pagan in this Commonwealth, and boy, I think it is required in this state that there be a YO indictment. It didn't happen here, and the fact they chose...
But that's not here before us, correct?
Well, Your Honor, I believe it is.
How did it get here?
We argued it in the court below.
And you appealed something?
We didn't file a cross appeal. We argued it on appeal here in our papers here as a reason that this court can reach, because it's in the record, to sustain her dismissal order. It's a different reason than what she relied on, but it's fully briefed in the papers before the court, and particularly before the juvenile court. There's a lengthy part of our motion to dismiss concerning it.
But she denied it.
She said she didn't think that was necessary.
Denied your motion to dismiss.
On that ground. motion had 5 different grounds, and she didn't agree with us on that ground, Your Honor.
And so that's not technically here before us. You say we can
You can reach it
use it as
because
an
it's...
alternative
exactly.
basis to support it?
Yes.
Do you think, with respect to the McCarthy motion to begin with, your position is both of the grounds on which the judge dismissed, that is McCarthy and Odell, just for abbreviation purposes, she did dismiss on both, correct?
Yes, she did.
What she didn't find, and I guess this goes to the without prejudice, what she didn't find was prosecutorial misconduct such that it should be with prejudice.
That's correct, Your Honor. And we argue that that is another ground that this court can reach if it wants to, because it's part of the record that it's I think to a certain extent blinking reality to think that this was just an oversight when the Commonwealth had the same transcript, when they had a decision by a different juvenile court judge that the same transcript contained no evidence of physical coercion, when we had argued its exculpatory nature all before the grand jury proceeding, and then they don't use it in the grand jury proceeding, and the testifying officer says something that is completely different than what is in the same transcript on the critical point.
Did the
So,
officer read his police report? Is that where this comes from?
he read his police report, which if you look at the date on it, was probably written 2 weeks after the Sane interview. And it's a very short 1-page police report, I believe, where he summarizes what he recalls happening during the Sane interview.
He summarizes both his conversation with
Yes.
the mother and then what happened.
That's correct. They're both summarized in that.
So he's read his police report. This is my report, and he read it into the record.
He did.
Okay.
And your client is going to be 21 on January 28th, is that right?
Your Honor, he will be 21 on January 28th, and the delay in this case has caused a prejudice that is so immense for him. He is now in a position where, as someone who is about to be 21 years old on a youthful offender indictment, he cannot be sentenced to a DYS facility. He must look at an adult prison sentence because of his age at this point, because of the tremendous delay. Even if you just look at the delay from when this court handed down Washington W. in June of 2010, that is 1.5 years. And that 1.5 years made it a certainty that he's looking at an adult prison sentence for conduct which began in 2007, allegedly, when he was 15 years old. He has lost perhaps the most profound and powerful mitigating factor that one can have in a case like this, which is his youth. He
All right,
cannot do
Counselor,
that.
Your time is up.
Thank you.